everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I'm coming to you from Santa Barbara, California. I'm here for a trial by human retreat where we work on our trial skills. We're working on opening statement, voir dire, closing argument, and all of the fears and worries that a trial lawyer has when they're presenting to a jury, when they're preparing for a trial, and when they're conducting a trial. And it's early here. It's a rainy morning. It's about 6 a.m. California time. And I'm up early because I'm from New York. I'm still on New York time. And I thought I'd make a video for you guys. And one of the requests I'm getting on the YouTube channel is to do a video for spinal cord stimulator verdicts. So that's what we're going to do today. And in fact, we're going to just do it right now. I haven't, read about this. I haven't researched this, but I've got my iPad here and I'm logged into one of the databases that I can research, like I've talked about before. I have access to a few of them, and there's Jury Verdict Reporters, there's Lexis, there's Westlaw, there's a few databases where they talk about what are the verdicts. And so this particular database, the way it works is you can actually search by type of injury. You can just type in search terms. You have gender. You can type in states, like any state. You can type in the attorney name and find out what a certain attorney has achieved in terms of settlements or verdicts. An expert name, for example, if you have a doctor and that doctor is going to testify, or any expert, you can find out about the expert. You could find out about a judge. So it's interesting. It's a really good one. I think it's one of the best ones out there. So I'm going to search for spinal cord stimulator, and let's see what it turns up. Okay, so actually there's a lot. There's 472 documents. Wow, 472 cases. And right away it's giving me some analysis. It's saying that the median, which is like the average case with a spinal cord stimulator, is $1,275,000. The lowest verdict with a spinal cord stimulator was actually only $2,336, and the highest verdict with this spinal cord stimulator was $44,162,890. And it actually tells you how they break down. For example, a decision by a judge, an arbitration, those are relatively small categories, like probably 5%. Then you have, it's kind of drawn in a pie chart. So then it has, if you click on the pie chart, it tells you exactly. Now settlements, out of all of the results, right, 472, settlements were 31%, 147 cases were settlements. And verdicts, jury verdicts, were 67.4%, 318 cases out of 472 were verdicts. So let's get into it. Let's see what some of these results are looking like. So here's one case, and of course you could sort it. You could sort it by amount, you could sort it by date. Let's sort it by date to see what's the most recent. Because if we sort it by amount, it's not going to be, it's going to start off with crazy $100 million cases, and then it's not going to be representative of actual results. But if we sort it by date, if we sort it by date, it goes back to the most recent one is from December 7th of 2023, and it's out of South Carolina. And I believe it's a case that I've done a video about recently. It's that Amazon case where a distracted Amazon driver caused an intersection crash. And there was like a fracture of the back at L3, there was annular tears, there was a cervical fusion, and the person also needed a spinal cord stimulator. So the thing with spinal cord stimulators is you're gonna find that that's a device, right, that you get implanted, and it's really like almost like a pain pump. The stimulator stimulates the nerves, stimulates the body so that you could deal with the pain, right? It's a way of managing or dealing with the pain. So it's almost like, some people will just take a Tylenol But if the pain is that bad, that the only thing you can do is have a spinal cord stimulator implanted. So you're not going to find too many verdicts, or maybe any verdicts, where someone just has a spinal cord stimulator, right, and nothing else, because that's done for a specific injury, for a specific condition, for a specific reason. And so the same thing is true here. So this person had a spinal cord stimulator, but he had a lot of other injuries. So yeah, what happened was he was a maintenance technician and he was riding a motorcycle in South Carolina. And as he entered the intersection, he struck the side of a van. And that van was an Amazon logistics van. And so let me actually view the entire document so I could see everything about the case. Here it is, okay. Oh yeah, they have actually very comprehensive facts. So yeah, so he struck, like I was saying, he struck the side of the van, and the van, it was a delivery associate that was driven and owned by Amazon. So I don't want to get into all the details because it's very, very detailed, but I've done a video recently. We had recorded a video about this case, and the case actually turned out to be very, very successful. Just as an aside, during the trial, the defendants made an offer for $1,233,000, and that offer was declined. The trial took 4 days. The jury thought about the case, or deliberated, for 4 hours, and the result was, okay, let's get into the specifics of the result. So there was past medical costs, and those were $453,000. There were future medical costs, and those were $9,339,000. There were past lost wages, known as economic damages, lost salary, and those were $210,000. Future lost wages were $1,108,000. And so just so you understand, when I say past and future, past is from the date of the crash up until the date of the trial, when the trial starts. That's considered past, from when it happened up until the trial starts. And future is from the date of the trial for the rest of the plaintiff's life, the injured person's life. And how do they know how long the person's going to live? Well, each state has their own jury instructions, and they have averages, statistical averages. I believe in most states right now, I mean, it should be the same really in all states, but I think according to the statistics, people are living to about 83, women a few years more than men, but about 82, 83 for men. So so the future was 1.1 million. Now for punitive damages, there was a punitive damage component against Amazon that was 30 million, and non-economic damages were 3,300,000. Non-economic damages are damages for pain and suffering, as well as loss of enjoyment of life. Punitive damages against MJV, which is a company, I guess a partner of Amazon, that was 50,000. Punitive damages against a particular individual, I believe the driver, was 175,000. And so the total amount that the plaintiff was supposed to receive, the total amount for the entire case was $44,637,147. So an amazing amount, really, really high amount, and a great job. So that's the first case, and that's the most recent case actually. Let's go into the next case. Let's see. If we go back to the results, we see the next case. And the next case, oh, another big one, wow. Okay, the next case was from May 25th of 2022. And this one is actually out of Texas, Harris County, which is Houston. And what happened here was a wrongful death case. What happened here is that a homemaker was shot by her next door neighbor. And she was survived by her husband, who was the plaintiff, right? The plaintiff becomes administrator of the estate of the person who gets killed or who dies, and then that family member continues the case. So what happened was the lawsuit basically alleged that the defendant was negligent for recklessly engaging in conduct that places another in imminent harm or imminent danger of serious bodily injury as well as for recklessly discharging a firearm inside the corporate limits of a city having a population of 100,000 or more. So it sounds like that was the statute, right? You can't recklessly discharge a firearm in a city, a municipality of 100,000 people or more. So they were just mimicking the words of the statute when they filed the lawsuit. And they alleged that the two people had a contentious relationship for the previous 5 months, ever since one of the persons helped the other person's wife and child leave him and return to the wife's family in a different country. So then the plaintiff claimed that on the date of the incident, the defendant was in her garage wrapping Christmas presents for her nephews. Her husband was sick in bed. The miniature schnauzer got into the neighbor's front yard, and then the plaintiff and the neighbor exchanged verbal hostilities. The plaintiff retrieved the dog and was on her side of the property line when the defendant fired a single shot from his 9mm handgun. So yeah, it was just like these two neighbors, and it was a death case. And so, let me see. I don't know how they pursued this, if there was insurance or if they were going after the neighbor personally. It doesn't really say. But it says that the trial took 2 days. The jury thought about it for 1.5 hours. The verdict was 12-0, so all 12 jurors agreed. And the way that it went down was that the jury found that the defendant was liable for the occurrence. Specifically, the jury found negligence and proximate cause as to the defendant and not as to the plaintiff. And it said that the plaintiff's damages totaled, and it was a large amount. It was $70 million, 70. And the way they broke it down was for the family members, there was loss of society, loss of pecuniary contribution, past and future mental anguish, past and future, and so the total, I guess it was the people who you leave behind, right? The family members. So one of them received 20 million, another one 20 million, and the estate received 20 million. And then there was also 10 million for, it was 10 million for the estate and 20 million for, I believe it was the husband received 20 million. But that's how they broke down the damages. They broke it down as loss of society, loss of pecuniary contribution. That means money, right? Monetary contribution that person made to the family, mental anguish, and so that's how they broke it down. So yeah, that's a big verdict, but I don't know if it's going to be collectible because of the issues with I don't know if insurance, or probably that's a huge verdict, 70 million. Okay, let's see what other cases. Here's a case out of Michigan. What happened here was a nerve injury was a known complication of knee surgery. So this was a medical malpractice case. What happened was there was a left knee arthroplasty revision, and I believe that it was a case against the doctor. So they thought that the doctor had made a mistake, and we could get into some of the details. I don't want to get into all the details because there's so many details here, but basically it was a medical malpractice, a surgical error. So the plaintiff was 67 years old. The plaintiff believed that he had this left knee arthroplasty revision, and the defendant, who was an orthopedic surgeon, performed the procedure, and he inadvertently injured the popliteal artery. And so the plaintiff claimed that this injury caused permanent nerve damage in her lower leg. And the plaintiffs had to have an expert, right? Because you're claiming there was a mistake, so you need your own doctor to be an expert. And the plaintiff's expert gave the opinion that this arterial injury must have resulted from negligence. The expert opinion was that the injury occurred because the defendant extended the knee before the prosthetic components were in place. The expert further claimed that those prosthetic components would have protected the artery from injury. But the defendant argued that the arterial and nerve injuries were known complications of revisions of prior revision surgeries. So this wasn't the first revision. This particular plaintiff had multiple surgeries, and this was like a revision of a revision. It just wasn't getting better, so they kept having to do revisions to fix the injury through surgeries. And so the defendant maintained that he told the plaintiff ahead of time about these potential complications. And so the injury was this nerve injury, and one of the ways that the plaintiff dealt with it was by implanting a spinal cord stimulator and a dorsal root ganglion stimulator, DRG stimulator. And so, but the verdict in this case, now let me tell you, before I tell you the verdict, it was a 4-day trial. There was a demand. This is the amount the plaintiff wanted, was $537,900. That was their demand to settle the case. And the verdict was 0. They found that there was no negligence. I guess they found that it was just a known complication. So medical malpractice cases are very tough. So yeah, let's go through back to, I guess when you go back, it starts sorting it by amount again with the high amounts on top. But if you sort it by date, that's what you get. You get the 44 million, then you get that one that we talked about, then you get this one 0. Here's one out of Texas. This is a motor vehicle rear ender. 39-year-old office manager who worked for a veterinarian was stopped in traffic and she got rear-ended. She had disc bulges in the neck, pre-existing conditions. Let me open the entire document. It says here, yeah, she had aggravation and exacerbation of pre-existing conditions. She had a fusion at C4, C5 about 2 years before the accident. So not from this crash, but 2 years before she had a fusion. She claimed that the accident caused neck pain radiating to her left, which was her non-dominant shoulder, and the jury charge included an eggshell plaintiff instruction. That means that you take your plaintiff as you find him or her. So if the plaintiff is like an eggshell, that they're easily brittle and they're likely to get hurt, you know, that's just the way that they are, and you're responsible for all the damages. So so the plaintiff went to her orthopedic surgeon 5 days after the accident, and he sent her for a neck MRI, which showed disc bulges. Then she had PT, and she had this spinal cord stimulator implanted in her cervical spine, and it was later removed. And the only medical bills that came into evidence were for pain management, including the implantation of the stimulator and the aquatic therapy. And the plaintiff was looking for $95,000 in past medicals, of which $89,000 were for pain management. She also was looking for, or seeking, as part of the lawsuit, this is what they asked for, $303,000 for future medical expenses, $150,000 for past physical pain and mental anguish, $150,000 for future physical pain and mental anguish, $50,000 for past physical impairment, $200,000 for future physical impairment, $50,000 for past loss of earnings, $150,000 for future loss of earnings, and at the plaintiff's counsel's request, disfigurement was also submitted, and he asked the jury to award 0 for that element. So I don't know what the strategy was to include disfigurement, but then told the jury that you should allow for 0. Then why include it? I don't really get the logic behind that. Maybe he was trying to be like credible. Maybe the disfigurement was so slight that he said, look, legally I could ask for disfigurement, but since it's so slight, you know what, don't put anything. I'm just guessing. I don't know what the argument would be there. You know, that's kind of, doesn't say. So the defendants argued that the plaintiff's neck problems were entirely pre-existing, that the pain management doctor who opined on causation acknowledged that he never saw the records or imaging from the plaintiff's ER visit or fusion. He also acknowledged that her imaging did not show any herniations or nerve root impingement. Also, the pain management bill was not itemized and was only a receipt, the defendant argued, and the custodian of records could not say what kind of injections were given or in what body part. And the defense also argued that the plaintiff continued to be as active as before, including riding horseback and doing gladiator workouts. In addition, the defense argued that the plaintiff complained of pain to the pain management doctor, but not to the other doctors seen at around the same time. So yeah, they went to the pain management doctor and said, I have pain, I need a spinal cord stimulator, I need it, because that was their doctor that was going to testify. But all the other doctors, they went to other doctors around the same time, like their orthopedic doctor, maybe chiropractor, other doctors, and they didn't complain about pain. So that's not so good. Now, the defense also emphasized gaps in treatment, gaps meaning people don't go to the doctor for like 3 months or 6 months or even sometimes a year. And the stimulator was implanted after more than a year of almost no treatment, the defense argued. Okay, so yeah, there was a year of no treatment at all, like the person didn't go anywhere. So they were arguing, look, if you're really hurt, wouldn't you go to a doctor? Wouldn't you get checked out? Wouldn't you try medication? But they didn't go anywhere, and then all of a sudden they go and just get a stimulator implanted. So they're like, this doesn't make sense. Also in her deposition, she did not disclose that she injured her left wrist and shoulder in a slip and fall in December 2020 while jogging, and had wrist surgery around March of 2021. And the defense also argued that nothing after the aquatherapy was related to the accident. So the result, now the jury found that the defendant was liable for the accident because it's a rear end. They determined that, they determined damages. The liability question asked if the defendant negligence was the proximate cause of the occurrence or injury. And plaintiff's counsel used a jury consultant. Okay, now, so the amount this was the amount that they recovered. It was a total amount of $116,000. So not a huge amount, but it was the past medical costs were $96,000. The past loss of earning capacity was $15,000. The past physical pain and mental anguish was $5,000. And so altogether it was $116,000. So essentially the jury just gave this plaintiff medical costs, right? They gave her loss of earning capacity, that she couldn't earn as much money as she would have had she not been injured. Her ability to earn was decreased by $15,000. This is all in the past, meaning from the date of the car crash up until the trial, nothing for the future. And $5,000 for past physical pain. So that's really low, $5,000 for a spinal cord stimulator in terms of physical pain. So I'm thinking that, this lawyer probably emphasized the medical bills more than the human story and the biography and the loss of enjoyment of life and the pain and suffering, because that's what I really think the case should be about, is the change in someone's life. Who was this before versus who is this now? Now, if you make it about the medical bills, that's what happens. You get the medical bills, but that's always going to be smaller, right? Medical bills are always going to be a tiny portion of the case, like 10%, maybe 5% medical bills. Your case is what you make it about. So if you make it about the medical bills, well, then you get the medical bills, but then you don't get anything else. So, you got to be careful with that. Okay, let's maybe do one more case. Here's a case, let me go back to date. When you go back, it starts sorting by amount again. So let me go back to date. So we did the case in Michigan. We did the case in Texas. Here's a case out of North Carolina. The defense accused plaintiff of exaggerating automobile injuries. There was a herniated disc in the lumbar as well as in the cervical, which is lower back and neck. And I guess there was a spinal cord stimulator. But the verdict was only $7,000. So I don't even know if it's worth going into the details. But basically it was a car crash and the person had some soft tissue injuries, and I guess they had a spinal cord stimulator. And for whatever reason, the defendant said the plaintiff is exaggerating, and they only allowed for $7,000. Here's another case out of Ohio. Here, this was in June of 2023. Here we had an improper back surgery. So this was a medical malpractice case, also requiring a spinal cord stimulator. But here, the result was actually $7,625,000. So it was a successful medical malpractice. Here's a case out of the Bronx where a plaintiff claimed he cannot work because of pain in his hand, and it was a labor law case, a construction case, and let me see. what happened here. This was a mediated settlement. This wasn't a this wasn't like a car accident. I mean, it wasn't a jury trial. I'm sorry, it wasn't a jury trial. It was a mediated settlement. It was a day laborer, and he was working as a plumber's assistant at a construction site, and he claimed that he was injured on the job. He hurt his hand, neck, back, and he sued the construction project. And he had pretty serious injuries. He had herniated discs. He had a hand injury with neurological RSD, reflex sympathetic dystrophy, which is also known as complex regional pain syndrome, or CRPS. And he had discectomies, decompression surgeries. And so the mediated settlement was $4 million. So this was $4 million. Here's one out of Pennsylvania where a truck driver struck by a steel panel at a construction site. This was in May of 2023. A truck driver was delivering steel panels on a flatbed truck to a construction site, and an excavator operator was removing panels from the truck, and the plaintiff was struck in the hip and knocked to the ground by one of the panels. So I guess when they were taking the panels off the truck, they weren't careful, and they dropped this $3,000 pound panel on this guy. And his injuries were a herniated disc at L5-S1, also reflex sympathetic dystrophy, complex regional pain syndrome, and he had a spinal cord stimulator. So I guess you'll find that like sometimes these injuries of CRPS or RSD will go hand in hand with a spinal cord stimulator, because a spinal cord stimulator, like I mentioned, is supposed to stimulate the spine and prevent the pain, because when you have the herniated disc, right, the leak from the disc is touching the nerves, and once those nerves get touched, that causes the pain. So you want the spinal cord stimulator to alleviate that, right, to make that go away or make that feel better, to lessen the pain. And the CRPS is the same kind of thing, where the nerves are just not acting right. It's kind of like the electrical system in your house, imagine, right? It's not working right. You're always getting a light bulb turning on in a corner of your house over and over again. So it's kind of like that. And so they work hand in hand. And so in this case, also, it bears true. So let me talk about the injuries real quick. Yeah, he had epidural injections, herniation at L5-S1. There was also a lumbar fusion at L3 and L4, and so the result was for the wife, because his wife had a loss of consortium claim, $250,000 for loss of consortium, and for the husband, the damages were $2 million. So the total result was $2,250,000. It was a 2-week trial, and yeah, it was a 2-week trial. Yeah, so that's not a bad result, If this was in Pennsylvania, in Philadelphia County, so in Philadelphia. And yeah, it's not a bad result. Okay. So yeah, that's just a little bit of a taste of spinal cord stimulators. Maybe I'll do a little more research and I'll try to see a specific type of case, like car accidents with, let's say, herniated discs, with nerve injuries and spinal cord stimulators. And then what I'll do is I'll pull those cases, I'll review them, I'll make an outline, and then I'll do a more comprehensive video about spinal cord stimulators as well as other topics. So please like and subscribe to our channel. Thank you so much for watching. And let us know if you have any questions. If you have a question and need a consultation, just text me, 347-566-9595. I'm happy to just text with you and find out a little bit about your case. Just give me like 1 or 2 sentence facts of what happened, your injury information, and what city you're in. And then you could let me know what you're looking, if you're just looking for some advice, you have a specific question, if you need an attorney, and I'll be happy to help in any way I can. Okay, have a great day, everyone. Have a great day. Thank you so much. Okay, bye-bye.